Welcome to the MyLaw CLE presentation. During today's presentation, you may access the course materials from the handout section located on your screen. Attendees seeking credit for this presentation, pay careful attention to the screen. A pop-up box will be displayed at various times during the presentation. You will need to click Confirm on the pop-up each time it appears to qualify for CLE credit. In order to receive CLE credit, you must also click on the link that will appear at the end of this presentation to initiate the certificate process.
All right, hey everybody, how you guys doing? My name is Adam Rawson, and I will be presenting along with my co-presenter David Terrace on the fundamentals of federal criminal defense. Now, let's talk a little bit about, first of all, who are we? What is our experience, and what are we going to be going over today? So, again, my name is Adam Rawson. I'm the founder and CEO of the Rawson Law Firm, and David Terrace is one of our partner attorneys, and he is the head of our federal and white-collar practice area of within the firm and within the criminal defense portion that we do. Let's talk a little bit about us. We have a very robust federal criminal defense practice that David heads, and we believe in helping good people when bad things happen to them. We're very proud of that. We believe in building relationships with our clients and really going the extra edge. Yes, they're going through a terrible time. Something terrible has happened to them, but it's about the full life cycle of not just the client, but people, right? Before, during, and after. So we really take a strong focus on helping people and making sure that when their case is over, that they can go back to their lives. They can be, happy, healthy, good family, have good families, and just continue to live a great life. That's truly our goal in everything that we do throughout the Rawson Law Firm. Now, introduction, right? Goals for today for this presentation. This is designed for first timers in federal court and experienced attorneys who need a little bit of a refresher in the nuances of federal criminal defense law. These are things we're not going to be going over things that you would learn necessarily from the books. This isn't going to be a big primer on federal criminal procedure. These are going to be the things that law school doesn't really teach you, that practicing in state court criminal defense, which is completely different than federal criminal defense. It's going to be those things that you won't learn from there as well. So, this is more of a practitioner's guide. You want to know the federal rules of evidence, you want to know the federal rules of criminal procedure, but again, those are things that can be learned from a book. So we're going to be really diving deep. It's not going to be an advanced presentation, but still, diving pretty deep into the nuances, the procedures. If you have a client and you get a federal case, well, what do you do, right? That's kind of the point of this, is to really get you folks through that and make sure that you don't just get through it, that you can represent your clients, professionally, ethically, and effectively, because that's why they're coming to you. They need that help. We're also going to be discussing, the differences. What is a federal crime? What makes up a federal crime versus a state crime? We're going to be talking about some different types of, categories of federal crimes, and we're going to be going over the major players in the federal system. Who are the players? Because the players in the federal system, are significantly different than the players in the state court system, and we want to make sure that everybody, that you folks are prepared and know and understand what things are going to look like. Now, here's the overview of our presentation today. I'm going to be walking you through the basics and the client interview portion, and then David's going to be taking on from investigation all the way through post-conviction. Okay. Now, let's go back just a little bit, right? From this slide, let's start really talking about, well, what are the basics, right? You know, what is a federal crime? So federal crimes as opposed to state crimes. Usually we're talking about a crime that involves, well, it has to involve a federal code, you know, a United States code violation, or one of the other federal legal codes. Usually we're talking about violations of the law that are carried over multiple states. So examples of that could be wire fraud and drug trafficking. And there's a few different categories of federal criminal, federal crimes. You know, usually the categories, we have fraud crimes, we have sex crimes, drug crimes. It could be violent crimes, you know, bank robbery, or other robberies under the Hobbs Act, and some other ones. And then again, going a little deeper on the crossing state lines. So what kind of examples of that can we have? One example would be a federal drug trafficking case if the drugs were purchased in Texas and driven to California, or if you left Florida to drive to even Georgia, right, or any other state in order to purchase drugs. It could be something, a violent crime such as kidnapping, and kidnapping, you know, a child or a person and taking them out of state. So those are ones where you would, you know, your client would physically move past the border, right? I think those are the easy ones. I think we all can pretty much wrap our head around that. But especially, you know, the last, 10, 20, 30, 40, 50 years, and even beyond, we have a lot of federal cases.
Let's say you didn't receive a target letter, but your client tells you, or you learn, or the agent or the prosecutor says, your client, we advise that your client bring counsel or have counsel, or we can appoint counsel. That means you're a target, because you don't have a right, and it's a case called Castigar that we'll talk about, but your right to counsel when it comes to grand juries and whether you can be compelled to testify or not really kicks in when you're a target. That's kind of getting a little technical and more than fundamental, but I wanted to show you what one of these looks like. You can see at the bottom, it says, if your counsel does not contact me, or you do not contact investigator Matthew Isman regarding appointment of counsel, I will assume you have elected not to resolve this matter at this time. In that event, the grand jury will consider the facts obtained during the course of this investigation. So again, this is what we're talking about when we say if somebody's already been designated a target, things could be moving pretty quickly. And that shows us that. And that's why we want to find that out as soon as possible, because not every target receives a letter. They don't have to send a letter, actually, unless they intend to try and compel your client to target in a grand jury. They really can't. Our clients would just take the fifth anyways. And another practice tip, this 14 days of receipt of this letter, very often the prosecutors are flexing their muscle when it comes to, we have a grand jury lined up. Get on the phone with the prosecutor as soon as possible. And here they're saying contact the investigator Matthew Isman. If there's a prosecutor involved, the investigator will direct you straight to have those kind of conversations with the prosecutor. I also wanted to show you here an example of a grand jury subpoena, a subpoena now. This was a case that was out of Massachusetts, but our client was in West Palm Beach. And some of the differences is you're commanded to appear in United States courthouse at this time to testify below the court's grand jury, or to, here it says, provide documentation. In lieu of a personal appearance, records may be produced on or before the date and time. If you have any questions, please contact the prosecutor. And then the prosecutor's information is down there. So more often than not, if your client comes to you having received a subpoena to testify or provide documentation, you can assume that it's not good to assume, but you can predict once you have the expertise and the comfortability to do so, that they're a witness or a suspect. Witnesses usually get less threatening subpoenas, or They're just called by an investigator. So again, federal government has a lot of tools at their disposal when it comes to an investigation that you have to know about and be prepared to deal with. Wiretapping, physical surveillance, monitoring online activity, controlled calls, or when they're having somebody who's cooperating with the government make a phone call and on a special phone and the government's on the other line, or it's being recorded. Subpoenaing bank records and financial documents, very common. Issuing grand jury subpoenas, which we talked about, search warrants, very similar to if you've dealt with search warrants in state courts. There's not much difference there, other than the search warrants might be a lot more complex in a federal investigation. And conducting witness interviews and proffer sessions. So this when we're talking about how do we achieve our goals in the investigation stage, is really a great time to transition into this very, very important concept in federal criminal defense, which is the concept of a proffer or cooperation. And it's not something that is very rare in state court. And it's an art, really. It takes a lot of practice, and it's good to speak to experienced attorneys about proffers, because they're some of the most crucial aspects of a federal criminal case. So, to proffer or not to proffer, and we'll talk about casting our letter and the protections that you get. So, more or less, a proffer in the context of, well, proffer is a word that's used, defined, I guess, would be to provide something to someone or to provide information. So in the federal criminal defense context, it's one of the biggest aspects of our job. It's a offer for our clients to provide information and cooperate with the government, usually in exchange for some sort of benefit at sentencing, and potentially no charges whatsoever. And that also depends a lot on where they are on that spectrum. Sometimes it's the only way to really gather the information that you need. It can be used as an investigatory tool by the defense, but you have to be very careful doing it that way, because the government is not as smart as they seem, but they are smart. You might also hear this proffer referred to as a queen for the day agreement. Sometimes it's also called a debrief, and the best time to do it is early if you're going to do it, and we'll talk about why, but it could come at various stages, even once a prosecution has already started. So usually the U.S. Attorney's Office or Department of Justice Criminal Trial Division is investigating someone, and if they either think that your client has information that would be valuable for them to know, or if you learn that your client, if your client is arrested and you get called while they're in jail, you usually don't get the complaint until that morning. Was a lot easier before the pandemic to then go to the courthouse and have an opportunity to sit down and review it with the client. But if they are just handed the complaint, obviously every one of our clients' intelligence levels is different, their reading capabilities, their literacy. So it's been an issue during the pandemic, whether they've had a chance to review it. If they haven't, then the judge will read the complaint. And that's like in state court when usually you say, well, waive reading. If they haven't reviewed it, then the judge will read the complaint. He will advise, the magistrate will advise your client or the defendant of his invocation rights, his rights to remain silent, his rights to counsel, and ask whether he already has private counsel, intends to hire private counsel, or needs counsel to be appointed to him because he's indigent, and then he'll do an indigency application, just like if you've practiced in state court or if you've ever been a public defender, which I was. Of course, you're entitled to representation under Gideon. If there's already a charging document, such as an indictment or an information, by the time we go in, and that's usually if we voluntarily surrender, that means there never was a complaint because there never was an arrest. So there already is a charging document that we've agreed to. We can either ask, or the magistrate can ask, to handle the arraignment at that time. We can plead not guilty always, even if you have an agreement with the prosecutor. I want to be very clear beforehand. You always still plead not guilty because it's not that agreement has not yet been entered into the record. So client could potentially change their mind if with consequences. If an indictment or information has already been filed, it can be entitled to a preliminary hearing under Rule 5.1. It's like an adversarial preliminary hearing in state court. If a client has been arrested on a complaint, then it's, I believe, within 14 to 21 days. I'm blanking now on Rule 5.1. But certainly within 21 days, you have to have a mini trial on whether there's probable cause for them to remain in custody. But preliminary hearings are not that common in private practice. Good practice note, something that's very different. If you're entering your appearance for a client, either at their first appearance or at arraignment, the judge will ask you whether you have filed a temporary or permanent appearance. Not really common in state court. Temporary means you're only there for the purposes of your only representation duties are the detention, bond, in terms of release, and that you're not the actual defense attorney who's going to be receiving the discovery, who's going to be arguing motions, filing motions, going to trial. Or if you enter into a permanent appearance, that means that you're all the way through, but you should also notate on the filing and in court whether that includes any sort of appeal or post-conviction if there is one, because the judge will ask you it. I always like saying it first. It gives you a lot of credibility, especially when you're new to federal court, because the judge will ask. So you can say, Judge, I've entered for permanent appearance, and the permanent appearance is to trial only. Doesn't mean you're going to trial. It just means that you're not doing any appellate work on the case, or you haven't been retained to yet. So the bail process is somewhat similar, but also somewhat different, and it can be often more favorable than in state court. The government can move for detention at the initial appearance. You should definitely, or you have to, be very familiar with 18 U.S.C. 3141 and certain kinds of cases, depending on the nature of the charge, which is laid out here. That's under 3142F, under 18 U.S.C. The government can automatically ask to detain your client for 3 days to prepare for a bail hearing. So it doesn't always happen like in state court at the initial appearance. It's more like a bond motion in state court, I guess, but it happens quicker probably than a bond motion, because depending on what district you're in. Case that involves violence, maximum sentence of life, minimum mandatory sentence of 10 years by the Controlled Substances Act, which is a lot of drug trafficking, or if any felony if the person has been convicted of 2 or more. Those are cases where they can ask for your client to be held an additional 3 days without a bond to prepare for a motion. And the motion is essentially those they get 3 days for. They can also ask for a motion or a bond hearing to be set even if your client is released. They can still file the motion to have pretrial detention. Not as common in all state courts, in all counties, like where I am in Broward County in South Florida. It's common in Palm Beach County. It's never really a thing. But in federal, they can do that if there is a serious flight risk, or if your client is a danger to the community, similar to state court. The defense can ask for up to 5 days to prepare for that bail hearing or that detention hearing, if we so choose. So types of bond are a little bit different in federal court, and you want to be really up on them. You have personal surety bond, which is not